Okay, good. There we go. It's working. All right. So did everyone get the document that I sent out earlier today? Okay,
Yes.
cool. I will say that to my knowledge, no one else besides me has actually reviewed that. So y'all are kind of in a position to tell me, hey, does this look like a good structure? And B, we can talk about the content. Like that is none of what's in there in content is set in stone. That was me trying to put together something that ended up not needing to be done on the timeline I thought it needed to be. So there's a whole bunch of stuff up in the air on that. It does not have to be the way that it is. I will say that in order for it to fit thematically and stylistically with the other performance standards that are being drafted, the standard 1.1 role of the child's attorney, standard 1.2, and then some kind of title, and then listing specific things within each of those subcategories, and then best practices afterward. That is the style that the rest of them are going towards. So I think we're going to try and mirror that. But pretty much like where things specifically fit, what the specific language is within each of those, that is still absolutely on the table. This was just me trying to take our notes and create more of a document that that could be used in a way that it no longer needs to be done. So let me go ahead and share that. Where's my share button? There it is. Okay. So does anybody have any questions about that before we dig into content and form and structure? I know a month ago when we had our last substantive meeting, we were anticipating getting through, I think, standard 7 was where we had decided to end up before moving on to the next pieces.
Are you asking if we have any questions about the
Yeah.
formatting? Is that what you're asking?
Questions, comments, if we want to dive straight into content, we can do that too.
Well, I have a question about
Sure.
the role of the child's attorney, and that's kind of contenty, but maybe it's quite possible I wasn't paying attention or didn't remember, but it's unclear to me whether or not you're saying if the child has diminished capacity due to age or some other reason, then you get to substitute your own judgment. It kind of sounds like that the way we phrased it. Maybe I'm misreading it.
I think most of these pulled, I think they all did. I will say the one area where I know I changed the standard from the OSB one is that the OSB said that you should make a judgment call as to what your client's capacity level is. And I turned that one into a must because I think you can't do your job unless you make that judgment call about what your client's capacity level is. Like that's like the first step is what are we even doing if you're not paying attention to what how capable your kid is? So
I agree, but if my child's a baby, let's say,
yeah,
obviously diminished capacity, not even a year old yet.
Yep.
Am I you know, am I using my judgment to decide what I think the baby would say to me if the baby could talk? Or am I using my judgment to say, this is what I think is best for this baby? That's what I'm not sure is clear in the role of the child's attorney. And that's an argument that we often have in Clackamas County with each other, because there are some attorneys who are like, well, I think this baby would want blah, blah, blah. And I'm like, well, I think the baby would want to be breastfed by its mother and be with its mother because that, you know, and so
yep.
I don't think that's clear in here. And I think we need to make it clear. And I hate going back to standard 1. I'm really sorry, Kevin. I know we're supposed to be all the way up to 7. But as I'm reading these, I'm like, oh, this doesn't resolve the ongoing argument that we have in Clackamas County, accusing each other of being shit attorneys for children. We don't say it that way, but you know what I mean? Like, Steve Rosenbaum gets all up my, oh, we're recording. Steve Rosenbaum suggests sometimes that I am not doing my job when I'm representing a child if he thinks that something should go one way. And he's like, if that child could talk to you, that child would say blah, blah, blah. And I'm like, no, I don't think, and so
Right.
we have this argument.
So
the other thing that I'm sorry.
No, you go ahead. Go ahead, Karen.
I also feel like we maybe need to add sufficient maturity, and because I feel like the maturity sounds like it's simply an age-based. Which, I mean, age is a huge part of it, but there are the really articulate, smart little 6-year-olds that can sure tell you what they want, and then there's 11-year-olds that, whether through trauma or having some diminished some DD, I don't know. I'm just wondering if we should, I don't want to keep using the word capacity, but like sufficient maturity and some other word, so that it doesn't just become because we get in the same fights that Rebecca's. And a lot of times it's like, well, my kid's only 6, and like it becomes like sometimes age can be like this really dispositive thing, which I don't think it should be.
It shouldn't be. I have an 11-year-old who has selective mutism, and she'll talk up a storm with me until I start talking about things that she doesn't want to talk about, and then she just grunts. And so yeah.
One thing I'm happy to do is flag certain things for us to come back and like have more of a discussion either offline or here. So first, Rebecca, to your point, I would have like my intent was to go towards the first option where you're trying to discern from your investigation what would this child tell me if they could, not what do I think is best.
Suck it, Rosenbaum. That's what I think.
Well, and I will say
I don't care if that's recorded.
There is another spot, and I can't remember if it's in 1.1 or elsewhere, but there is a spot where it directly says that the attorney for the child should never become an advocate for best interests, because that is someone else's job, right? Our job is to do what our client wants, not to do what we think is best.
That's the argument I have with the CASAs. They're like, how can you as an attorney advocate for this? That's not in the child's best interest. And I'm like, well, aren't you doing your job? That's your job, lady. So yeah, DHS's job. I don't think they need one more person in the courtroom advocating for best interest. So yeah, I just don't want people to be able to look at one part and say, oh, I'm doing it. Whatever.
Do you have an idea as to, or do you want to take on trying to put come up with some language to put in this particular section to make that clearer?
I can take that on, and then people can tear it apart and say this is good or this is bad, and that's fine with me. Like that's totally fine. But I can at least get us started on some language that I think would be better. I'm happy to do that.
Okay.
So this is just a structural question, and maybe it's just the way that my brain works. I've never, stopped having the outlines from law school. But under 1.2, you have the paragraph labeled A, and I think that's a really great way for people to refer to the paragraphs under 1.1 if each of them is labeled A, B, C.
I'll come back to that. Let me put this note in, and then I will come right back to that. Okay, so you're right, and you'll see that most of them have that sub A, sub B, sub C styling. This one I thought was all one thing. Like it's a very long standard, but it is the first standard. The first standard is you have to determine what is your client's capacity, and based off of that determination, this is how you operate, if that makes sense. I'm okay with other people disagreeing and thinking it's better to break it out into subsections, but that was how I conceptualized it when I wrote it.
Then I think we should start the standard with basically some version of, as an initial matter, you need to determine your client's capacity to direct you.
Mm.
And these are the ways that you do that. Kind of, I mean, this all kind of fits under that then.
Yeah.
But just sort of being very clear.
Okay. I can work out some kind of restructuring on that.
I don't know if this is your experience, Dawn, but at Multnomah County, I don't think that we overtly argue about substituted judgment versus best interest very often, but there are definitely camps about that.
That is correct.
Okay. Okay, cool. Do we want to go through and I realize that like our original aim with the what the task was at our last substantive meeting was to go more towards the I think it was 4, 5, 6, and 7 standards. But given that we now have a like an actual draft, I'm happy to revisit some of this other stuff as well. Like I'm cool with that. We do need to eventually get through everything, but yeah. So, was there anything else? Rebecca, did that take care of? Cool. All right.
It did, Kevin. Thank you.
All right.
There may always be the camps and the arguments from people because we're lawyers. We just like to argue. It's kind of in our nature. But the more clear we can make it, and I'm happy to work some language on that too.
Sweet. Thank you.
Yeah.
Okay. Where I think my next inclination is probably to head towards standard number 4, just since that's where we left off. But does anyone have somewhere that they want to pick up before we get there? And I also realize y'all got this like 3-4 hours ago, maybe. If you haven't had a chance to look through the whole thing, don't worry about it. Send comments offline as well. That's fine. I will say that my just a sec. I will say my goal would be for us to finish the child standards by our have a draft of the child standards by our next meeting. So, Dawn, go ahead.
Kevin, since our last meeting, I have been engaged in a week-long abusive head trauma case.
Okay.
And nonstop. So I believe that I sent you my feedback.
You did.
Okay. So for 4 to 7. So and then we showed up at the meeting. We had to take a pause, and now we're doing what we were. Okay.
Yep.
I can't remember that feedback, but you had it. It was good, I'm sure.
Sounds like it was your abusive head trauma, Dawn. Did you? Dawn's like, I don't even know what happened. I'm out of it.
I do know what happened. There's going to be a great appellate case.
I've got one of those too. I've got one of those too.
I love those great appellate cases. I'm not writing for you, Judge. I'm writing for the person who's going to overturn you. All right. Okay. So let's. I did draft in this document standards. And it mostly kind of fits the original structure of the OSB standards. Let's see, there we go. It follows along pretty close for standards 4 through 7. So if y'all don't mind, we can just work within this draft and put our notes in here.
And I can't read that, so I'm looking at the bigger one to my right on my gigantic monitor. Okay, now I can. Yeah, now I can. All right.
Cool. I can always increase font size and stuff. So, okay, cool. So Looking through, and Dawn, let me see if I can find the comments that you had last time, because I don't remember if I
pulled up.
saved. I don't remember if I saved them in the Dropbox. And this document is not in the Dropbox because it is on our internal file sharing thing, and that doesn't play with Dropbox quite right. So I'm gonna, once we're through, I'm gonna put a version of it into the Dropbox.
I've got mine. I pulled mine up.
Okay. All right. Okay. Do you want to go ahead and lead us through some of your stuff?
Well, I flagged in the should. I just put a note. My first thing was we have previously discussed the use of should versus shall versus may, which is best here. That was a lot of mine. It's like we just need to decide whether we're going to use should, shall, or may. And I think you already spoke to that, Kevin, but I've got a lot of little flags.
Let's go through that because, sorry, go ahead.
So that was, I think, pretty much on any should, shall, or may, I put a flag and said, hey, see my comment above. We just need to figure out which one we want to use.
Okay. So let's go through it. We can start with 4.1a. Child client's lawyer should actively represent the child in preparation of the case as well as at hearings. Is that a should or a must? I don't think it's only a best practice.
I agree. I had also highlighted the language that was the child client's lawyer should advocate for the child client both in and out of court. And I'm wondering to what extent we can incorporate the idea that it's the preparation of the case, it's the hearing, but it's also all those meetings that we go to that are often more important than the hearing. Like it's important for a child's lawyer to show up at FDMs
and I think you reference it in the contract. So you are right. You're contracting for lawyers to have the capacity to do these things and to do those things. So we want to be clear that that is your job. Like, right. And the hours, and you also monitor hours to make sure that lawyers have the capacity, resource capacity to do this by having us tell you we're doing it because we have to send activity logs. Right?
That is not the case for all contractors. That is just a PCRP thing.
Oh, yep, that's true.
But
well, I would say looking forward, I anticipate that would be something lawyers are doing.
Well, and I would also note, I think the eventuality, and it's not going to happen in this contract cycle, but the eventuality is for us to move to a workload model statewide for all contracts. And I think a component of that does become timekeeping. I have no idea what the time frame on that is or would be. It didn't happen for this contract cycle. So, but I did, Jennifer, to your point also, I did the child lawyer should advocate both in and out. That is under 4.2. So it's in there. And nearly everything up to, I mean, there is some stuff that I just was like, okay, this is a little surplusage. I really can't fit all of the everything in here. But most of what's in the OSB standards, honestly, it was mostly just me copy and pasting and just reorganizing and some little tweaks as to language. But to take us back to 4.1, is this a should or is it a must? Actively represent the child client in preparation of a case as well as at hearings.
It seems to me like a basic lawyer function, a necessary, it seems like a must to me.
They all seem like musts to me.
Yes.
I read Don's comments and it was like, let's be consistent. So if we're going to say should, then we should say should throughout. If we're going to say must, we should say must throughout. I think that if we're setting standards and these are the standards that we expect, that they're musts.
Okay.
Should seems discretionary.
I do think there are discretionary things in here. I do. Not everything
I do
to
too, but
me.
I think these are musts
Okay.
for sure.
Otherwise, you might have a client, an attorney sleeping at trial, and then they're like, "But I only should have done it."
Yeah, you're not wrong. Okay, so both A and B are musts.
Yeah, then. So now I'm having to look. I'm looking at my screen for my notes, and this screen for the updates.
Okay.
Okay.
So must actively represent child client in the preparation of case as well as at hearings. Must develop a theory and strategy of the case to implement at hearings, including development of factual and legal issues.
Yeah.
All right. Okay. Within that, best practices, regardless of alignment, should develop the lawyer's own theory and strategy of the case to ensure an independent voice. Should not merely be fact finder, but rather should zealously advocate a position on behalf of their client. May overlap, but should be prepared to present the child client's position independently. I will say this is the area where I've had the hardest time, like being able to do it is just, oh, y'all didn't actually subpoena your witnesses. Crap.
Kevin, I'm gonna have to join from a different device. So
Okay.
will you look for me in a minute in the
Absolutely.
waiting room? Thank you.
Yep. Okay. When consistent with the child client's interest, child client's lawyer should take every appropriate step to expedite the proceedings. I'll say that's definitely not a must. I mean, to me, I don't think that it's a requirement that we push to get everything out the door as fast as possible. But that I'm open to others feeling differently.
I think you're telling us to strategize, and you might have all kinds of strategies, right? And
right.
I don't know that. I mean, they should be thinking about why they're doing it before you do anything. Why are you doing it?
Okay.
Right. Sometimes, I mean, if your kid wants to go home, sometimes giving time is going to make that more likely if the parents are getting it together slowly or whatever. So, yeah.
Right.
Okay. Child client's lawyer should communicate with lawyers for other parties, CASA, caseworker, everybody, to learn about the child client's progress and child's views of the case as appropriate. And then when child client desires visits and when necessary, child client's lawyer should seek court orders to compel child welfare to provide appropriate visitation consistent with child's wishes, may also need to take action to enforce previously entered orders. Anything we want to change with respect to these?
I'm just debating about the should in that first sentence of that paragraph, because the lead-in is when the child client desires and when necessary. Like when your child client has told you what they want, shouldn't, I mean, is that a should or is that a must? I mean, I think that there are times when we, for whatever reason, might make a different choice. But
I mean, I will say from my experience, sometimes you get more. I mean, assuming, of course, that you can. I mean, there's that gradient, right? Like, I'm going to work with the agency to try and get things until it's clear that that's not going to work. At which point I go to the court, right? Does it necessarily like? I feel like putting this one as a must is like, all right, well, you go nuclear at every option, which doesn't do the if I'm willing to work with people outside of court more, then for me, I get more it's more likely I'll get what I want on other cases too. Which, granted, in here it definitely says you can't sacrifice your client for the sake of the relationship with the other parties, but I do think there's work room there. It's not always file the motion every time.
No,
Yeah,
I mean
no,
we don't have space on our docket for every kid that wants, an overnight this weekend as opposed to next weekend. We can't always get it in there, and would ruin our own credibility if we pushed it too much.
And maybe that's part of the when necessary part. Like, okay, maybe I've worked with the agency and now it's necessary for me to file a motion. Maybe that's when it becomes a must, but it does feel a little weird to put a must here. Like that seems fairly, what's the word I'm looking for? Black and white. I don't know.
I guess I'm okay with that being should, because there's circumstances. There's always,
Right.
Anecdotally, I could come up with 15 different cases in which, depending on what's going on, it's appropriate or not appropriate to seek a court order. The issue for us is that we're trying to come up with standards for people who maybe don't have as much experience as everybody
Right.
on this committee, and who, don't have the common sense or don't have the experience to understand this is a time I'm going to go nuclear, or this is a time when it doesn't make sense. Because I, as you all know, can and will go nuclear when necessary. I try not to do it all the time. I don't have the energy for that. And it's not good for my client, right? I have to think about my client first. And so I guess I guess should rather than must is okay, given the fact that of what I just said. Like there's circumstances that we're not going to be able to articulate all the circumstances in the standards in which it might not be appropriate to go to court.
All right,
but generally, let's go to court. But
be willing to go to court on it, right? Like that's the important thing, is be willing to go to court on these things.
Well, that's just it. And that's what I tell my younger lawyers is, like, you try something. Like if something is triable, try it. And that way the DA's office knows and the AG's office knows that you're not afraid to go to court. And they can't use that, well, I guess I'll see you in trial. Like nobody says that to me. I guess I'll see you in trial. Because they know they know they will. They will, in fact, see me in trial. And so once they understand that about you, like when I was in the DA's office, there was a couple of defense attorneys that we knew they set stuff for trial, and we were like, whatever. We don't have to work that case at all because they're going to plead out. We know that they never go to trial. So you don't want to be that attorney.
Okay. All right. Let's go to 4.2. Child client's lawyer should advocate for the child client both in and out. I suspect folks might think this is a must.
Must.
Yeah.
It's a must. In fact, I think might have been Jennifer or Karen that said it. Sometimes out of court is more important than in court.
Oh, I wholeheartedly agree.
Yeah.
Child client's lawyer should engage in case planning and advocate for a permanency plan and social services that will help achieve the child's client's goals in the case.
So Dawn put remove permanency, and I agree with Dawn because the plan that your child wants might not be a permanency plan, or what is the court or others might call a permanency plan. But I'll let Dawn explain why she thought that. I jumped in. Sorry,
I have to
Dawn.
find it on my own document because the documents are slightly inconsistent with the. I think I'm close. When
Dawn, all you said was remove permanency. You don't have a lot of notes about it.
Why? Because I recognize that because the child's client's goal might not be a permanent plan, right? I'm always torn between that, because the actual legal definition of permanency plan is not, this is your plan forever. It's something other than having the government be your guardian. That's what it means. When they came many, many years ago, it's something other than the government, DHS, being your guardian. But the reality of the case is, at least in Multnomah County, that we come up against is our child client's goal may not be the permanency plan. They may just be just fine and dandy. It's what is the plan that they want, and given what their options are in a dependency case. That's why I put it in there.
See, now I always approach this from all of the plans are permanency plans. It's just which one are we going towards? Like return to parent is a permanency plan. Our plan is that you will be permanently back with your parent.
Well, that's I guess yeah. I mean, I guess that's a philosophical thing too.
Yeah.
There's no such thing in any human being's life as a permanent plan.
I mean, none of them are actually permanent because people get hit by buses. But like, no, yeah,
guardian can get tired of you and come in court and say they're not fine. And how many times, right?
Yep.
They're staying up late at night and smoking marijuana. I don't want to be the guardian anymore. And here we are again.
Not just guardianship.
So, some foster parent can spank a kid, and the next thing you know, DHS is removing the kid. Right? So there's no such thing.
So an advocate for a plan and social services.
I mean, the reality is that we might philosophically disagree with the wording of it, but that is the term of art. We have permanency hearings. We have.
So why not say dependency court
or just case
dependency plan. Court plan, a dependency case plan, because you're limited to plans that are within the scope of the dependency court, right?
I mean, I kind of disagree in that we're in the out of court advocacy section, and that we could be advocating for a case plan with DHS, right? Like, and we just say maybe case plan, that's broad enough to cover.
When I say court, I mean the jurisdiction. They have a lawyer in a dependency case.
Yeah.
It's a dependency case. They have a lawyer, and that is what I'm hired to work on. I am not hired to work on their trust account that they inherited from grandpa or anything, right? I'm hired to, you're not paying me to be their lawyer for anything but the work associated with a dependency case. That's what the government pays me to do.
You are correct, but I would include in that working with the agency to do, like, because the say the adoption selection committee, that's not a court thing, right? Like that's an agency function. But I would include that in this, right? That's out of court advocacy. So if we just put like case plan instead of permanency plan, I think we're broad enough to cover what we're discussing, maybe.
I think case plan other than the word of permanency plan. And not court, you're out of court, but the work is related to the reason why the child is a ward of the court.
How do others feel? Let's see if we've got consensus here.
I don't think I have a super strong opinion on this one. I mean, I think that I can see I'm abstaining.
So I think the problem for me is that I'm thinking about, for example, when case plan works better for me because I got a teenage client who's had a beef with their parents. Their parents are like, get them the F out of my house. Maybe they're a crossover case and the parent's the victim of like an assault or a harassment or a UUV or something like that. And the plan is return home. And the kid's like, absolutely not. But they don't know what other plan, right? Like, what do they want? You can't be advocating for APLA at that point. You can't be advocating for permanent foster care. And so, you might not be advocating for a permanency plan, right? Like you might be advocating for a temporary plan until your kid gets his poo together or whatever, or until the crossover case is resolved, or until treatment happens or something like that. And so that's why for me, like for littles, I think it's much easier. But what I think representing teenagers is like the most difficult job to do. I would take prison dad over teenagers any day because they're difficult because of things like this. Like you often have crossovers and they have strong opinions, and their strong opinions are often not rooted in reason because they're teenagers. It's right. So there you go. That's my opinion.
I'm gonna flag this one and we can think about it and maybe come to a consensus later. Again, all of this is like I think getting through, we'll get a lot of consensus and we can flag areas for further discussion. You guys got this today. Like we can, I mean, the language is from the original OSB standards, but this is a slightly different tweak of what we were doing. So, all right. If client's goal is reunification with the parent, child client's lawyer should advocate strongly for frequent visitation in family-friendly setting. Is this one also a must? Or are we good with should here?
I guess there's a few variables in there. I mean, I think it's almost always a must, but I mean, there are, I don't know. I think it's typically something that is a must. But I do feel like we have to give people room to use judgment, and we all of us that have done this a long time. It doesn't. I mean, there's just so many weird circumstances that come up that you want people to be able to pivot and use their judgment.
Okay.
Yeah, I feel like if we spent time, each of us could come up with an example where it got really complicated.
Fair.
Yeah.
All right. D, child client's lawyer or lawyer's agent may not contact represented party without consent of the party's lawyers. That's an ethics rule. I don't think we change anything about this.
Oh, and I just take it out because it was an ethics rule.
I think that's my view too. Like, we're not including all the ethics rules in here, are we? So why this one?
I thought we agreed to say that part of our standards are you must comply with the rules of ethics.
So I don't disagree with you that we can take the tack of removing things that are just straight up ethics rules. I know that the resources for this particular ethics rule aren't phenomenal outside of the OSB standards. Granted, the OSB standards still exist and people can reference them. Maybe we can point them in that direction for additional understanding of this. I personally kind of like having the, hey, but also keep in mind, everyone in the system is represented by an attorney, and there are going to be times where you have to get permission. Because there's the best practices part includes the, keep in mind, you've got other people here who have attorneys. The OSB definitely went further and explained far, far greater detail. I'm cool with removing it if that's what our consensus is. I like having the reminder, but we can also just reference, hey, look at the OSB standards. They've got a more in-depth description of why you need to pay attention to this.
Well, you actually literally do reference it, right? Yep. So the contract references the standards and the ethics code. So I'm a person, I vote for taking it out.
Okay.
I would vote that way too. I think, and maybe this is me being a little defensive, like, just because we represent kids doesn't mean we're not real lawyers, people. We know what we're doing.
That's fair. All right. I will go through and I'll remove the stuff out of the best practices that would deal with that. as well. Okay. That's basically those paragraphs. So best practice, lawyer should advocate for an effective visit plan consistent with child client's wishes. Court and agency may need to be encouraged to develop visitation plans that best fit needs of the individual agency. Anything to change there? All right. Okay. Yep. Okay.
Just as
All
an
that.
aside, Kevin,
Yeah.
given all I just said, I would say that I am glad that you put in there, or that it was already in there, to keep in mind that there may be other parties at meetings, because I think it's something that we all, me included, can sometimes forget and be like, oh no.
Right. Well, and there, yeah, I mean, therein lies part of it is like if you're attending a meeting and somebody else's client is there, and I would advocate for attorneys attending as many of these meetings as possible, but not all attorneys abide by that same ethos, or can't facilitate getting into all of those meetings. And yeah, it's crucial. Like I've been in the meeting where my one of the other parents is there, and I'm like, I can't say anything. I'm not allowed to say anything at all here. Okay. Standard 5, pre-petition work. Child client's lawyer should counsel the child client about his or her rights in the investigation stage, as well as realistic probability of achieving client's goals. I mean, I feel like that's basic lawyering. That's probably a must. Is everybody else thinking the same?
Why is my standard not flowing with your standards?
I don't know.
Like I'm looking at, like, I'm reading what you wrote here, but it's not lining up with what I pulled out. Never mind. I put my notes, my highlighted notes on the standards from the bar standards. And so when I look to see what my notes were, they're not matching this anymore. Like you've got A and B right together, and I've got a note that says there is no B. Where did B? Like there is no B, so why do we need an A?
So the original standards had the A, and like it's basically just restated in like the first two actions. So I was like, why even have that first statement? Just combine the two actions together. That's the standard, if that makes sense. So you're right.
Yeah, but I didn't know that that's what you'd done, and I hadn't read your new one yet. So I'm like, my little note feedback is not very helpful anymore.
No worries. Do people think this is a more of a must than a should?
Yes, it's a must. You must counsel.
It 100% is a must. You got to talk to your client. What the flippity foo-fa?
All right. Well, the OSB said it was a should, so.
OSB. Okay.
Well,
all right.
That would be my feedback for them to update theirs.
Child client's lawyer should discuss available services and help the child client gain access to those in which they wish to participate.
I think that's a should, only because it can get a little tricky depending on what is available and what's not. So that, I think, if it's a must, it puts the burden on the lawyer to do DHS's job. That's my fear about making it a must.
There is that side too. Okay. All right. If client would be eligible for appointed counsel, y'all can reach out to us, get counsel appointed. If you're not familiar with pre-petition work, please contact me offline. We can talk about it. Okay, and during pre-petition, I think maybe just the goal of the representation maybe just depends on the child client's wishes.
So when we're talking about that, I've had OPDC reach out to me multiple times and ask for a pre-petition appointment for a parent on a case. When that's happening as an administrator, should I be saying, yeah, that the kid should get a lawyer too? Like, is that something that we should be doing? Because I have never done that.
That is an exceedingly good question, and probably something that we need to determine ourselves internally as to what guidance to have on those things. I don't know that that's necessarily a practice standard, because this is written from the standpoint of acting in the attorney role, and I don't think it is like a representative's job to say, hey, someone else needs a lawyer too, right?
No, I don't think it is. But as I'm listening to us talk about this, I'm thinking, well, wait a minute. I am familiar with pre-petition work, because usually what happens is you reach out to me and say, hey, do you have capacity? This is somebody's being investigated in your county and they want to talk to a lawyer. And we get somebody appointed for that person who's asked for a lawyer. But I don't then say, hey, Kevin, give me the name of all the kids and the dads and everybody, because everybody gets a lawyer now. It's like that one person who asked gets a lawyer. And so I'm just wondering.
Yeah, that's probably a better conversation for a different venue. And
that's
also
fine.
we're like,
I'm putting a bug in your ear.
No, you're right to do it. It is also 6, and unfortunately I do have a hard cap. So
I'm so sorry.
Oh, you're good. I'm gonna go ahead. I think because our next session is in 2 weeks, if I remember right. Let me double check. It's either 2 or 3. 2. It's 2. It's on the 6th. So for the next session, let's try and have the children's standard, like comments on the children's standards finished. And if you could take a look through, what I would really appreciate, one thing that we could probably get through really quickly, if you're looking through, is check through this document, and everywhere it says should or must, check to make sure that that's right. Like I don't think there's many musts that are going to not be musts anymore, but there very well likely are some shoulds that will become musts. And mark up and let me know which ones we all think should become musts. And I think especially the one that's probably going to be the most contentious, I would bet, is going to be things around when you visit the kids. So, all right. Thanks, everybody. I appreciate everyone's time and work. Good to see you all again, and I will see you in a couple of weeks. Thank you.
And you're sending out this, Kevin? You're sending out this version?
Yeah, I'll send out. I'll pull down another copy of it and send out with the comments and the changes from today.
Thank you.
Yep.
Okay, thanks a lot. Take care, everybody.
Take care, everybody.